How's it going, everybody? So I have an update for you on the Franklin Armory Title I issue and the issue of the state of California treating other firearms to be so-called assault weapons. So let's talk about this. But real quick, before we jump into this video, if you think the state of California needs to stop infringing on our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to thank one of the main supporters of the channel, which is Route 66 Shooting Sports Park in San Bernardino. If you came out to that Armed in May event with me and Reno May, you know how amazing that range is, how amazing the staff is. So if you're in the Southern California area, if you're in the LA area, I highly recommend you check them out. And thank you, Route 66, for supporting this channel. Also want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So real quick, before we get into talking about the Franklin Armory Title I and some updates on this issue, I have to give a quick disclaimer. Although I am a licensed and practicing attorney in the state of California, this video in no way is intended to provide you legal advice. The intent of this video is also not intended to create an attorney-client relationship between me and the viewer. I'm just providing some basic information and education with this video so that those of you who are watching this in the state of California, you can make educated decisions based on the information I provide. So just had to throw that quick disclaimer out there. Now let's talk about what's going on. So the state of California and the California Department of Justice just sent out some news and some information regarding registration of other firearms, or the Franklin Armory Title I. Some people kind of like to call them that, but essentially they are other firearms. Now, I think I gotta provide some background on this issue for those of you who kind of don't understand what's going on. So an other firearm is a firearm that did not meet the assault weapons definition in the state of California Penal Code 30515. An other did not meet the definition of what California or the federal government considered to be either a rifle, pistol, or shotgun. Therefore, because it was not a rifle, pistol, or shotgun, it was legal for someone to possess, and it was a way for people to get around California's overburdensome ban on so-called assault weapons. California didn't like that people found a way around this, and so they decided to amend the penal code through passing SB 118. Through that bill, an amendment was added, and the definition of so-called assault weapons in the state of California was expanded to include others and Title I's from Franklin Armory. Now, another issue with this history of others in the state of California is that Franklin Armory created the Title I, they manufactured it, and they intended to sell it legally to people in the state of California. Well, the state of California would not amend and change their DROS process to include an other drop-down menu. So consumers in California could not go and purchase the Title I from Franklin Armory because they couldn't DROS it. And essentially the actions of the DOJ have been challenged by Franklin Armory in 2 other lawsuits, but that's not what we're talking about here in this video. But it's relevant because it kind of goes to all of this changing of definitions and language in the state of California. Now, the most important information in this video is that the registration period has now been confirmed by the California Department of Justice. They're going to add in that registration component that was included in SB 118. And essentially, if you legally possessed an other firearm prior to September 1st of 2020, you can then register it with the state of California as a so-called assault weapon. And the registration period has been confirmed, and it will open at 9 a.m. on October 1st of 2021 and will run until the end of December 31st. Now, a quick aside here, and something I think is important to mention. This is not the registration period opening back up for those bullet button ARs that people did not register or couldn't register because the state of California had issues a few years back. That one is in relation to the Sharp v. Becerra settlement agreement. This is not the registration period for those bullet buttons, so don't try to register them here during this period. This is specifically for others. Now, with the registration of these firearms with the state of California, you will have to submit 5 photos of the firearm. There's one picture that you have to take with a tape measure of the total length of the firearm. And then you have to take a picture of the barrel, a picture of the magazine, and then a photo of the right and left side of the receiver. So that's the background of how we got here, the information on registration, some of the requirements. Now let's talk about other firearms in California and if you should potentially register them and how people maybe became in possession of others. So the most commonly possessed others in California, and in my opinion, one of the strongest legal bases for someone being in legal possession of an other firearm, were those people who purchased a Franklin Armory CA7, 9, or 11 and then converted it into an other. So after purchasing that Franklin Armory lower, which was DROSed as a pistol, people then would add a 16-inch upper on that pistol lower they would have a pistol brace on it, and because it was configured in that way, they could have a flash hider on it, a detachable magazine, then they would put a vertical foregrip on it, and again, it could also have a pistol grip. So this configuration would not be defined as a pistol because of the 16-inch barrel. Because California's definition of a pistol is not defined as something that has that 16-inch barrel. It obviously wouldn't be a shotgun either because it didn't meet the definitions of what a shotgun is. And it wouldn't be considered a rifle because the lower started first as a Droz pistol. And then since the pistol had a brace on it and a vertical foregrip, that would mean it was intended to be fired as a firearm, not a pistol or a rifle. And it was intended to be fired with two hands and wasn't intended to be shouldered. So that is kind of those weird workarounds where things are specifically defined in California's penal code. They are also specifically defined in the federal government, the NFA and the GCA. And these other firearms didn't meet any of those definitions based on the way they were configured. So that was really one of the safest ways, in my opinion, one of the most legal ways that people became in possession of these types of other firearms. There was some other ways that people would do it as well, which are a little bit more of a gray area. Another way people would do it is if they had a lower receiver that they acquired prior to 2014. And that's important, and that date of 2014 is important because prior to 2014, you didn't actually have to Droz your lower receivers as a rifle in the state of California. So they were not Drozed as a semi-automatic centerfire rifle like current lower receivers are. So they essentially had no distinction on them and they weren't registered with the state of California. So people would take that stripped lower receiver that didn't have a rifle designation on it and then convert it in a way that it was considered to be an other. Again, a little bit more of a gray area. Now, an even more gray area way that people would go into things is they would buy a post-2014 stripped lower, which was Drozed as a rifle with the state of California, and then they would convert that into an other. This is much more of a gray area, like I said. In my opinion, I think now you're definitely starting to skirt the line. And in my opinion, I'm not 100% safe with telling people that that is a valid other, because again, if I wouldn't tell my family member that that is a 100% safe thing, again, because we don't have the DOJ telling us that that is actually a legitimate way to make an other. They've indicated that some of these other ways may potentially be more valid, especially when you look at some of the discussions around SB 118, some of the arguments that happened back and forth where people were talking about people converting, Franklin Armory CA7s, 9s, and 11s. Much more of a safe area than this type of configuration. So those are kind of the main ways that people became in possession of what they deemed to be others. Again, I kind of rank them based on the ways that I think were more legal, a little bit more safer, kind of going into the more gray areas, a lot more questions. And that's important because now when you're considering whether or not you're going to register this firearm with the state of California as an assault weapon, you have to also take into account where you kind of fall on that scale. Is this other leaning more towards, we kind of recognize that this was a legal way to possess this firearm, more into the gray area where we don't really know. So that's kind of part of that analysis you have to do for yourself if you're going to decide to register with the state of California. Now, if it was me, and if you're asking my opinion whether or not I would register an other firearm with the state of California as an assault weapon, my opinion is no, I would not register an other with the state of California as an assault weapon. Because with that comes more restrictions on the firearm, like you have transportation restrictions, you have storage restrictions within your home, and even there's inheritance restrictions as well, and resale restrictions. So with it just comes a whole lot more issues, and personally, I just don't see the value of registering something with the state of California as an actual assault weapon. So remember, this will go on a register as an actual assault weapon, and California will mark you as a possessor of one of these items. For me, if I had an other that started as a CA7, 9, or 11, I would simply convert it back into the fixed magazine pistol build, or I would change it back to the original configuration that I purchased it from Franklin Armory. However, I do understand that some of you watching this may think that you want to register with the state of California, that you don't want to convert it because you see there is a good opportunity to still have something, a firearm, configured in a way that's more traditional of an AR-15. Also, another thing to keep in mind is if you built one of those based on those 2014 lowers, another thing you might want to keep in mind is that 2014 lower is not registered with the state of California. So essentially you have a firearm in your possession legally that is not on the state of California or the DOJ's radar. So do you really want to then take that 2014, pre-2014 lower and register it with the state of California and put it on their radar? Again, a decision you will have to make for yourself, but me personally, no, I wouldn't. I see more value in having that legally possessed off the radar lower than registering an assault weapon with the state of California. So this is still something that's developing. It's still something new. It's going to start in October, go into December. And as we get more information, as we get more clarity on what the DOJ is doing, maybe what they're considering to be valid others, I will definitely update you guys. But that's just my general takeaway on this situation, because I knew people would be asking me about this, what I recommend, what I thought about the whole process. And again, my general takeaway, my general recommendation would be that if it was me, and if I was in this situation, I would not be registering that other with the state of California. I would just configure it in a way that would be a legally compliant, fixed mag pistol, or just configure it back to that Franklin Armory. Or if it was, one of those 2014 lowers, configure it back into maybe a featureless rifle. So that's kind of what I would do. That's my takeaway. But if you guys have any questions, if you are thinking about this or you have any questions like that, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All these things help to fuel the algorithm or fuel Al Gore's rhythm. It signals to YouTube that you see value in these videos, in this type of two-way news, and then it pushes it to more people. So thank you so much to everybody who's liked, commented, subscribed, who's supporting this channel. You are definitely impacting this channel, helping me spread the word about Second Amendment, helping me spread the word about information like this that people do need to know. So if you don't have a comment in mind, just comment down below that you're commenting to fuel the algorithm, and I will really appreciate that. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will maintain by armed scholars.